Hello, good evening. This is Velu Balashran speaking. And today I'm bringing to you a new video class on the overview and study plan, which we have been doing for a few other chapters also. Your LRDR video is on the way. Today I'm going to take a very important topic which has been requested by students, and that is Prevention of Money Laundering Act. Usually students don't study this chapter or just read the RTP and go, but it is very important from exam point of view. A mandatory question is been asked from this chapter, so we have to understand it thoroughly, especially conceptual knowledge, and of course I will support you with the study plan also. So overview and study plan of Prevention of Money Laundering Act, in short PMLA. What is prevention of money laundering, etc.? The conceptual knowledge I will give you. Statutory, that is different. Yeah. What is money laundering? ML in short. Money laundering is the process of making large amounts of money generated by a criminal activity such as drug trafficking, terrorist funding, etc., etc. The money from the criminal activity is considered dirty, illegal source, dirty money. And the process of launderers is to make it look clean. So what is money laundering? Simple. Money laundering means getting money from illegal source, criminal activity, and putting that money into the market or the economy and trying to make that money clean. So this is basically a process of making the dirty money into clean money. I'll repeat again. Money laundering is basically a criminal activity whereby illegal sourced money is being pumped into the economy to make it clean. So that is the simplest definition. The act does not say the meaning of money laundering. So I will repeat again. Money laundering means laundering the money from illegal source, taking it from illegal source and it putting into the economy and making it a clean money. So this is a criminal activity. The sources is from criminal activity. The sources is from drug trafficking, etc. So ill-gotten money, dirty money sourced from illegal activities are put into the economy to make it clean. This is called as money laundering. Laundering the money, disguising the source of the money, making the money into new form. That is it. So that's the meaning of the term money laundering. To be more specific, usually launderers or the criminal activity doers does this activity, money laundering, by following three processes. First process is called placement, second one is called layering, third one is called integration. Even though a practical question has been asked by the institute by the examiner, you can explain the meaning of the money laundering and you can explain the three process also, so that the examiner will feel that you are thorough with the basics of this provision and the basis of the concept. What is placement? Putting the dirty money into the legitimate financial system. First stage, they will put the dirty money into the legal system, that is the economy. Second one is they used to conceal the source of the money through series of transactions. They will never allow you to identify. So they will put money, for example, say 10 crore. They will put 2 crores one sector, 2 crores another sector, 3 crores another sector, 4 crores another sector. In order to hide, conceal the source of the money, they will put into the different streams. That is called layering. Putting one side, putting another side, putting another side, back. That is called layering. And the third most dangerous stage is integration. They will withdraw the money which is being put into the market. They will withdraw the money put into the legitimate market and they will take for another criminal activity. See, this is the process of money laundering. What is the process of money laundering? PLI. What is the process of money laundering? Placement, putting the money. Layering, putting into the different parts of the economy. Third one, integration. When need arises, they will take back all the money and they will take that to the another criminal activity. So that there on the process will go on. So this is money laundering, and money laundering typically passes through these three stages. Students, now we will see what is the law, and there is some committee. Before I go to the international level, in India we had passed the Prevention of Money Laundering Act 2002. In short, we call as PMLA, Prevention of Money Laundering Act 2002, which has came effect from 1st July 2005. In international level, the Group 7, by the international body has constituted a committee called Financial Action Task Force, FATF to monitor this criminal activity in the international scenario. And you must understand one that not in the world, most of the developed countries, the FATF plays a crucial role in curbing the activities of money laundering in an international scale. Okay, in India, we had passed, our Parliament has passed the Prevention of Money Laundering Act 2002, which has came into place from 1st July 2005. In fact, we are going to study the provisions. I am going to give you the bird's eye view of which are the provisions or the study plan to study this Prevention of Money Laundering Act 2002. So here we go, the study plan. Basically, you have to start with section 3, 4, 5. Section 3 speaks about offense. It states that any offense including indulging in money laundering is called as an offense of money laundering. The law act does not say what is money laundering. The act only says whoever indulges, whoever conceals, whoever supports money laundering will be offenders of money laundering. Section 3. Section 4 is very important. For exam point of view, it speaks about the penalty. This penalty says that rigorous imprisonment which shall not be less than the minimum penalty will be 3 years rigorous imprisonment, which may extend to 7 years rigorous imprisonment. So 3 to 7 years is the imprisonment, and also will be liable for fine. But if the offense involves narcotic drugs, then the maximum 7 years will be extended to 10 years. So that is the penalty for violating or offense indulging or involving in money laundering. 3 years minimum regressment penalty to maximum 7 years regressment penalty. If the offense involved narcotic drugs, then the 7 years will be again extended to up to 10 years. So 3 to 10 it will become. So that's it. Section 5 speaks about property attachment. The fund which you got from the money laundering or the proceeds which you had made from money laundering will be attached, and that will be a property subject to attachment under the PMLA Act. So that's section 5. Students, another part of very important area is section 12, which gives or casts an obligation on the banking and financial institutions. Section 12. I'll just give you bird's eye view of section 12. Section 12 says that all records and registers of bank accounts, financial institution accounts which have an abnormal transaction or transactions having doubtful, currency transactions, the records of the same should be maintained by the bank or the financial institutions, and that record should be given if asked by the director in charge under the Act. You have to give that information to the director in charge of this Act, PMLA Act, and keep that accounts, registers, and records of that suspicious bank accounts and the financial institution accounts even after the account has been closed. So that is very important area, which the role which can be played by the banks and financial institutions to curb this activity of money laundering. So friends, this slide itself speaks about 4 sections you have to study. Section 3, offense. Section 4, penalty. Section 5, attachment of property. Section 12, responsibility of the banks and financial institutions to curb the, curbing the activities of, money laundering. Here we go, the next pack. Next pack, little bit on procedural aspect. You can just read this procedural aspect. Section 13, powers of the director under this Act. Appeal to the appellate tribunal. Section 26, Section 35, power of appellate tribunal. Appeal to the Honorable High Court. Section 42, appeal to the Special Court constituted to this Act. Section 43, and very important area. This it's been asked by the exam. The institute has asked this. The offences under the Money Laundering Prevention of Money Laundering Act is cognizable. What is a cognizable offence? Cognizable offence means an offence which can be arrested without a warrant. The offenders can be arrested without a warrant, so that is why the offence is being categorized as cognizable offence. And of course, non-bailable, you will not get, the offender will not get a bail too. So this slide is not that much important. It deals with procedures only, but you have to read and have a good knowledge about the same. Especially read section 45 very importantly, because it speaks about cognizable and non-bailable offence under this Act. So here we go. This is the last slide, presumably this last slide which is very, 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 very important, this Act. Most of the students fail to study this chapter or this area because they will read the basics and go. No, for institute's point of exam point of view, this slide is very important because it speaks about reciprocal arrangement of sharing information between our country and our parenting country, the other country. So the other country we call as the contracting state here. So for example, Indian country and India and vis-a-vis the US, vis-a-vis the UK, we have arrangements and agreements between us to share information with respect to offenders involved in the money laundering. So students, take it from me, this slide is going to change your mark into examination, because one question is assured from this area. What are the areas you have to study? You have to go to the areas to deal with what is called as a reciprocal arrangement between countries regarding money laundering. Second one is very important, section 56, agreements with foreign country, the contracting state, agreements with India and UK, what are the terms of the agreement, what are the intricacies of the agreement. Next one, letter of request to a contracting state. We can request another state to give information, another country to give information of an offender. Assistance to a contracting state, two things. One thing, you can give assistance to other country also, you can give assistance to other, you can request assistance from other country, and you can also get assistance from other country. So this is the area which is very important. For exam point of view, I had earmarked a box here which is very important area. You must understand the basis of this reciprocal agreement is enforcing the money laundering act of one country, prevention of money laundering act of one country in other country, enforcing their law in our country, enforcing our law in their country. That is why I call the first E, enforcement. Second one is exchange of information, giving information regarding these type of bank accounts, the information regarding the money of laundering offenders list, the details of this list to another country. So that is the very basic essential of this, the reciprocal arrangement. So reciprocal arrangement objectives or ingredients of reciprocal arrangements are three. One is enforcement, two is giving exchange of information, and third one is supporting the investigation. Don't forget, students, three things: EEI, enforcing the law, exchange of information, and investigation with respect to money laundering offenders. I am not talking about internal affairs, we are talking about external affairs, that is from one country to another country. Enforce the law. Enforcing money laundering law here, of an offender which is being come from another country. Exchange of information which we gathered about such type of offenders to other country. And of course, when a request has been received from a contracting state to investigate into a person who is an offender, expected or prospective offender, then we will investigate them and give the report to the other country. So this is very important slide, students, and a question is very frequently asked from this area: reciprocal arrangements, agreements with foreign countries, section 56, letter of request to a contracting state, section 57, assistance to a contract state, section 58, and is very important, these areas. Lastly, to conclude this chapter, you have to study offense by companies, section 70. This is common for FEMA. This is common for all the financial contravention laws. When an offense under this act is done by a company, how will you deal with? When an offense is being done by a company, every officer who is in default will be liable. If he can prove that he has not done or he has acted honestly, he will be exonerated. The law will only fix those persons who are responsible for that offense. So I will repeat again: offense by company means company will be liable, and officers who are in default or who are liable for the same, who had done the offense, will be liable to this prosecutions and all. But if he proves, if an officer, for example, X is been prosecuted, but if the X is proving that he is not done that offense, he had done things honestly, and with his knowledge he has not done anything, then he will be exonerated and the actual culprit will be caught. So students, this will end this today's area. I will repeat which are the areas we have to study. Point number one, you have to go to the slides once again. Point number one, you have to study is, of course, the meaning of money laundering. Second one is the process of money laundering. Third one is you have to study section 3, section 4 offense punishment, section 5 property attachment, and very importantly section 12, which deals with the responsibility of banks and financial institutions. Then you have to go into the procedural aspects, in which you have to very importantly study the cognizable, the offense under this act is cognizable and non-bailable. And the last one is very, very important, that international arrangement for curbing the money laundering practices, reciprocal arrangement, I already told, for enforcing this law, for giving exchange of information, for investigation. This slide is going to change your mark, dear students. Okay, so this will conclude this section, and I like to request you to regularly visit my channel, Velu Balkrishnan, and of course request topics to velubalkrishnan@gmail.com, so that we will have more productive, these type of video classes. Please subscribe to my channel so that whenever I upload a video, you will get notifications. With this, I am ending this class. More classes are coming soon. Stay wealthy, stay healthy. Thank you.